Hi guys, it's Houston immigration attorney Pegah Rahgozar. Welcome back for another episode of Wednesday Wisdom with Pegah. A little bit about the Rahgozar law firm. Our principal office is located in Houston, Texas, but we do take cases all across the U.S. and outside of the U.S. advising on U.S. immigration laws. Our office phone number is 832-792-3636, and you can learn more about this topic as well as other topics and more about me on our website at www.rahgozarlaw.com. Today's topic is about the credible fear interview process. But before I dive in, as usual, I'd like to inform you that any information discussed in today's video is for informational purposes only and should not be construed as legal advice. Because immigration is a fact-intensive area of the law, be sure to seek proper legal advice from an experienced immigration attorney before filing any sort of application with immigration. Just to inform you guys, don't forget to join me this Sunday, June 30th at 3 p.m. Central Standard Time, live on the air for my monthly 1-hour show called What's My Status, where you can ask me case-specific questions and receive mini consultations live on the air. You can learn more about this show and the call-in number by visiting our Facebook page, Rahgozar Law Firm PLLC, and look under the Events tab. Please join the event and share it with anyone who may be interested. Some of the latest in the immigration world, some latest news. So this past Sunday, ICE began a series of raids in 10 major cities, including Houston, Chicago, Los Angeles, Miami, and several other major cities. If you or someone you know could be a target for these raids, especially if you have a past deportation order, then put together an emergency plan should you get picked up by ICE. Have important contact numbers for family, friends, and an attorney available. Also have important documents such as birth certificates, marriage certificates, passports, and other documentation that could help your immigration case in a safe location where a family member or friend can access them on your behalf. Also, be sure to know what to do with minor children should you get picked up. Things like how and where they should be picked up, or where to be picked up from school or by whom, and who to stay with. These are tough times, so it's really crucial that you prepare in case you are picked up during an immigration raid, particularly if you have a past deportation order. We are definitely seeing the immigration crisis at the border with Mexico become more and more real every day. Unbearable images were released just yesterday of a father and his 23-month-old daughter trying to make it across the Rio Grande River, and unfortunately drowned. I mean, we're hearing news every day of the treatment of families, especially of children being held in detention facilities. So immigration is just in crisis right now. Immigrants are facing horrible conditions, horrible dilemmas trying to get to the border, trying to enter the U.S., and with the treatment they receive while they're in custody. Just yesterday, Tuesday, June 25th, 2019, a divided House of Representatives voted for a bill that could send $4.5 billion in humanitarian aid to the border to help address some of the horrific conditions facing migrants, attaching, of course, significant rules on how this money could be spent. Some of the provisions include language that would require Customs and Border Protection to establish plans and protocols to deliver medical care, improve nutrition and hygiene, and train personnel to ensure the health and safety of children and adults while they're in custody. A similar bill with fewer strings binding on President Trump has drawn bipartisan support in the Senate. Now, of course, the spending bill that passed the House still faces a tough time and a tough path to enactment. Nonetheless, the bill will also face a veto, and the House and the Senate must now decide how to reconcile their differences on the two separate bills they've drafted. So we'll see by the end of the week, hopefully, whether this spending bill for humanitarian aid to the border will actually pass. In other news, tensions have been rising in the past 2 weeks between the U.S. and Iran. Fears of war between the United States and Iran have intensified after a U.S. drone was shot down by Iranian forces. Washington and Tehran disputed the circumstances of the drone shoot down, with Iran saying that the unmanned spy plane was downed as it encroached Iranian airspace, while the U.S. says that the aircraft was hit over international territory. 6 European countries said that preserving the 2015 nuclear deal under Obama has become more important than ever amid escalating tensions between the U.S. and Iran. Of course, for the time being, the U.S. has imposed further sanctions targeting Iran and the Iran Supreme Leader Ayatollah Ali Khamenei. War doesn't seem imminent, but that could change in the near future depending on how things go between the two countries. So stay tuned with that. Now into today's topic, the credible fear interview process. So many non-citizens of the U.S., particularly from the southern border, attempt to enter the U.S. without documentation, without any sort of visa, border crossing card, or a green card, or they try to use false documentation to enter the U.S. Now, the law requires that these individuals be placed into deportation proceedings under a process called expedited removal, which I addressed in a previous live video. And according to this, they will be sent home promptly without a hearing unless they request asylum. When a Customs and Border Protection agent or a CBP agent detains a non-citizen for not having proper documentation or for attempting to commit fraud to enter the U.S., CBP will ask that individual if they have a fear of returning to their home country. If the person says no, then they'll promptly be removed from the U.S. However, if the person expresses fear of returning to their home country based on persecution or torture, then the CBP agent will set up a credible fear interview process with an asylum officer. When do credible fear interviews take place? Well, after the applicant is taken into custody, the CBP agent will give them an orientation to the credible fear process, and they'll also be given a list of pro bono, which is free or low-cost legal service providers. Then USCIS requires a wait time of at least 48 hours after the individual is in custody and at the detention site before conducting the credible fear interview. This is in order to give the applicant, the detainee, time to recover from their journey and or contact an attorney to prepare for their interview. This period, of course, can be waived by the individuals, and nowadays it could actually take more than just 48 hours to get an interview conducted. What happens at the credible fear interview? Well, the asylum officer, who is an officer with USCIS, will conduct the interview. So the Border Patrol agent will not. They will just make a general assessment of whether you claim fear and then refer it over to the asylum officer, who will then conduct the interview. The asylum officer will ask a series of questions, either in person or over the phone. And of course, an interpreter will be present to translate questions into the detainee's native language. The types of questions that will be asked will be information about the person's background, things like their date of birth, their home country, and any family ties in the U.S. They will also then ask questions about why you fear returning to your home country. Based on those answers, the officer will follow up questions to get a better picture of your claim. The officer will also ask why it is that you're being persecuted and whether you have ever been threatened or harmed due to your race or ethnicity, your religion, your nationality, your political opinion, or because you belong to a specific social group. This is, of course, a critical point in the interview, because if the fear is not related to one of the categories I just mentioned, then the asylum claim will likely fail. The asylum officer will also ask questions about whether you have faced torture or mistreatment by the government officials in your home country. The officer will then ask about situations that would bar you from applying for asylum, things like whether you've ever persecuted other individuals, or if you've committed a crime in your home country or any other country, or if you're associated with any terrorist organizations or groups accused of using violence. Lastly, the officer will give you a brief summary of your statement and ask you whether you would like to add anything further to your testimony. Within a few days or weeks after, you'll receive a decision on your case made by the asylum officer. If you or someone you know has made a claim of fear of returning to their home country and has been scheduled for a credible fear interview, then please contact our office at 832-792-3636, make an appointment, and we can discuss your case. So what happens if the individual is found to have a credible fear? Well, if the individual is found to have a credible fear of persecution or torture by establishing that there is a significant possibility that they have been or will be persecuted under one of the 5 categories that I mentioned, then their case will be referred to an immigration judge where they'll be given the opportunity to present their case in a full hearing and represent themselves with an attorney on their asylum case. What will happen if the asylum officer does not find that you have a credible fear? In that case, if the officer does not find that the individual has a credible fear of persecution or torture, they can still request an immigration judge to review the negative decision. If no review is requested or the immigration judge sides with the asylum officer on their negative decision, then the individual will be removed from the United States. If the immigration judge, however, makes a positive finding, then the case is then again referred for a full hearing on the merits of your asylum claim. What will happen before the immigration judge once your case is referred for a full hearing on the asylum claim? Well, the individual does get a chance to apply for asylum and for withholding of removal before the immigration judge. This is known as the defensive asylum process. The burden of proof is on the individual to establish that they're eligible for asylum or other protections from the U.S., and the individual will be able to present evidence, testimony, witnesses, and experts on their case. If you or someone you know has had a credible fear case referred to an immigration judge and needs help with their hearing, then please contact our office at 832-792-3636. Make an appointment to discuss your case. Now, finally, are there any mandatory bars to establishing a credible fear of persecution or torture or for your asylum claim? The asylum officer does not make the final determination whether an individual is subject to any mandatory bars to asylum or for withholding of removal when they're initially interviewing the applicant to see if they have established a credible fear of persecution. They will only notate the possibility that a mandatory bar might apply. However, the immigration judge is the actual individual who will consider whether or not you're barred from a grant of asylum or withholding of removal. And once again, an individual may not be granted asylum or withholding of removal if he or she has done one of the following. If the person has persecuted other individuals on account of their race, religion, nationality, membership in a particular social group, or political opinion, or if the individual has been convicted of a particularly serious crime, or if the individual has committed a serious non-political crime outside of the United States, or if the individual has firmly resettled in a third country other than their own, or last but not least, there are reasonable grounds to believe that the individual is a danger to the security and welfare of the United States. If a mandatory bar does apply under one of the grounds I just mentioned, but the individual has established that he or she would be tortured in the country of return, then the immigration judge in his or her discretion can grant a deferral of removal. Of course, a grant of deferral of removal does not provide the same benefits as a grant of asylum. Namely, asylum provides you with ultimately getting to a green card, whereas withholding of removal or deferral of removal does not. The best thing you get is your removal withheld and you obtain a work authorization. In some of these cases, ICE may even keep you in detention. If you or someone you know has been scheduled for a full hearing before an immigration judge for their asylum case and needs help to present their case at trial, then please contact our office at 832-792-3636, make an appointment, and we can discuss your case. If you guys have any questions related to this topic or any other topics, then please contact our office at 832-792-3636 and make an appointment. As mentioned previously, don't forget that to join me this Sunday, June 30th at 3 p.m. Central Standard Time, live on the air for my monthly 1-hour show called What's My Status, where you can actually ask me case-specific questions and receive a mini consultation live on the air. You can learn more about our show and the call-in number by visiting our Facebook page, Rahgozar Law Firm PLLC. You can look under the events tab. Please join the event and also be sure to share it with anyone who may be interested. Once again, that concludes another episode of Wednesday Wisdom with Pegah. Thank you guys, and I will see you guys next week for another episode of Wednesday Wisdom. Have a good night.